The dangerous part of patent costs is not just what you pay to file it. In this video, I'm going to give you a plain English breakdown of what a patent actually costs in 2026. This is general education. Do not consider this to be legal advice. Now let's break down where that money goes. First, provisional versus utility. A provisional patent application is not a granted patent. It's a temporary filing that gives you a filing date and lets you say patent pending for up to 12 months. It's usually cheaper because it's not examined by the patent office. There are no formal patent claims that are required in the same way as a utility patent application, and the government filing fee is typically in the low hundreds, depending on whether you qualify as a micro entity, small entity, or large entity. If you do it yourself, your out-of-pocket government cost might be relatively low. So the biggest beginner mistake is thinking that provisional is the patent and the utility is just a simple upgrade. It's not. The provisional is often the starting line. The utility is where the real examination and major costs begin. Now let's talk about the cost categories. First, government fees. These are the official USPTO fees. They depend on your entity status. For provisional, think low hundreds. For utility application, the filing, search, and examination fees together may be in the high hundreds to even a few $1,000s before you even get into the later fees. Second, attorney or patent agent fees. This is usually the largest cost. A cheap filing that misses the real invention can be way more expensive in the long run than a better filing that costs more upfront. Third, drawings. Patent drawings matter. For most inventions, you need professional drawings that show the parts, relationships, and variations of the invention clearly. Drawings may cost a few $100s for something simple, or $1,000 to $2,000 for a more complex product with many drawing figures. Fourth, patent search costs. You can do a basic search yourself using Google Patents, the USPTO database, and other online searching tools. Because remember, a search doesn't guarantee that your patent will be approved, but it can help you avoid spending thousands on an invention that's already too close to existing patents or products. Fifth, office actions. This is a major surprise cost to many. After you file a utility application, the examiner may reject some of the claims. That's normal. Your attorney then is going to respond with arguments or amendments. Each response can cost $1,500 to $4,000 or more, depending on complexity. Sixth, continuation costs. A continuation can be a big advantage. A continuation is a later filed application that's connected to your earlier application. It's often used to pursue additional claim scope. This can be quite valuable because it can land you an additional patent, but it's not free. It can easily create another round of attorney fees and government fees. For some inventions, continuation strategy is important. And for beginners, it's one of the costs they usually don't see coming. And one more warning. If you want international protection, costs can multiply quickly. A US filing only protects you in the US. If you want further protection, there are additional applications you're going to need to file in those other jurisdictions, and that's going to cost even more money. Now let's look at three common paths. Path one, the do-it-yourself starter path. This is for inventors who are very early, still testing the idea, and are trying to preserve a possible filing date without spending much. Path two, the attorney-guided provisional. This is often a good middle path when the invention is promised, but you're not ready for the full utility costs yet. Path three, the full utility filing. This is the serious path. When your invention is developed early enough, and you want examination and full potentially enforceable rights. So if you're ready, you may file a utility application as the first step of protection, or you may file it within 12 months after a provisional that you've already filed. This is a more expensive step, but it's the actual route towards getting a granted utility patent. It's usually best when you understand the invention, the market, the prior art, and the business reason for spending the money. And here's where the protection type matters. If you're protecting how something works, functions, operates, or is made, you're usually thinking about utility patent protection. So before you file anything, use this checklist. Number one, write down what's actually new. Be specific. Number two, decide what type of protection fits. Number three, do a patent search before you spend heavily. Number four, estimate the full path, not just the first filing. Number five, mark your deadlines. If you file a provisional, the 12-month deadline is critical. Number six, connect your patent budget to the business plan. A patent is not automatically a business. Before spending heavily, ask whether the invention has a market. If you want the next steps, watch the videos in this sequence. First, what to do when you have an invention idea. Second, how to do a beginner patent search. Third, provisional patent costs explained. Fourth, utility versus design patents. And fifth, the most common patent mistakes inventors make before they file. Because the goal is not just to file something. The goal is to spend the right amount of money at the right stage on the right type of protection.